In today's video, we describe how FTC substantiation rules can make or break the marketing materials that you make for your health and wellness product. I'm Michael H. Cohen, founding attorney at Cohen Healthcare Law Group. We've advised over 1,000 healthcare industry clients on healthcare and FDA legal issues, including many companies with medical devices, dietary supplements, cosmetics, and OTC drugs. And so, we understand the pickle these dietary supplement and cosmetics manufacturers, you, are in when the choice is whether to follow the rules, quite literally and slavishly to the ends of the earth, or take a chance with super aggressive marketing claims. Today, we'll educate you on 3 points. 1, how FTC substantiation rules shape your marketing claims, and how paying attention to these rules can keep you out of the regulatory crosshairs. 2, how to balance compliance versus your need and desire for profit without losing your shirt one way or another. 3, what kinds of claims will make or break you if enforcement takes an interest. First of all, how FTC substantiation rules can make a huge difference in your market share. In a previous video, we had talked about how FDA, like FTC, requires that claims for health and wellness products be substantiated or supported by evidence. We also noted that the standard for health and wellness is much higher than advertising for other products in general. For most products, the FTC requires that the company have a reasonable basis for their claims. For a health and wellness product, on the other hand, the FTC requires competent and reliable scientific evidence. This is much more than a reasonable basis. Typically, the FTC requires clinical trials. Second, how to balance compliance versus revenue. This is a bit tricky. On the one hand, the more aggressive your claims, the bigger your sales revenue. And the more you are 100% compliant, the smaller your market share. So, what do? We counsel our health and wellness clients with sensitivity to their needs, interests, and desires, and marketing oomph, and also with respect to what the laws, regulations, and policy guidance documents require when they ask for close attention. Third, how to stay clear from FDA and FTC regulatory tripwires. Now, FTC tells us that it pays the most attention to certain kinds of claims. These include claims about human health or safety, for example, that the product reduces the risk of a certain disease. Next, claims that consumers themselves could not easily evaluate on their own. For example, a claim that risks are reduced by a certain percentage, which is very precise. Next, claims that are deceptive because of the fine print or because the ad simply does not have sufficient qualifying language, or because the claim is simply exaggerated or unproven. The next thing you need to know is that having a disclaimer such as results may vary doesn't necessarily solve your FTC issues. Anyone who has a health and wellness industry product on the market needs to understand these nuanced rules in order to gain market share without unnecessarily triggering FDA or FTC enforcement. That's the battle. Thanks for watching. If you still have questions, click on the link below, cohenhealthcare.com/contact to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.